Court rising able. Appeal in the matter of Tingdene Marinas Ltd and Jaffe.
Yes, Mr. Rudd.
Please, your ladyship, sign here on behalf of the appellant, Tingdene Marinas Ltd, who are the owners of a marina in Huntingdon. The learned friend Mr. Cottle appears on behalf of the respondent, Ms. Jaffe, who is the owner and occupier of a houseboat that is moored at the marina, owned by the appellant company. You have today before you, you have an appeal against decision of the Upper Tribunal to uphold the determination of the first tier tribunal that the appellant must provide the respondent with an agreement under the Mobile Homes Act 1983 relating to her houseboat. As I said, currently the respondent moors a houseboat at the appellant's marina, and that is pursuant to a mooring agreement that provides no security of tenure at the mooring agreement, but an agreement under the Mobile Homes Act 1983 would provide security of tenure, which can only be terminated in certain specific circumstances. Can I just check that your ladyships have all of the documentation before you? You should have a 2-volume hearing bundle.
Yes.
An authorities bundle.
That arrived very late.
Yes, I apologise for that. The directions that we had said it was to be served by yesterday, e-filed, which we served the day before, but I think that it appeared there'd been an error in the direction that was sent out. It was expected last week. I do apologise for that, and I hope it hasn't caused too much inconvenience.
Well, it has caused quite a lot of inconvenience, I should say, because with a case like this, normally if one was operating electronically, it's not too difficult, but a case like this, you've got to move around between the statute and the authorities, and much easier to do that in hard copy. But you know, I'm not blaming anybody. It's just we may have to go a bit more slowly today as a result of that, because my ladies and I might be trying to catch up with the hard copies.
Okay, I was intending to take your ladyships through the statutes
Yes.
In some detail. I'm sure my learned friend will take you to the elements that he relies upon.
Yes.
So I do apologise for that
No, don't
inconvenience.
worry.
And you should have an additional witness statement from Mr. Coftree, the respondent solicitor.
Yes, that's here on the bench.
It deals with the details of the respondent's notice.
Right. Do my ladies have copies of that?
I think I have that in soft
think
copy.
I've got that. Yeah, let me just check. Yes. Yes.
Well, that is all the documents that at the moment I'm aware that you should have. So the issue before your ladyships, just in summary, is the Mobile Home Act 1983 only applies to caravans which are in permanent residential use and have a permission for that, planning permission for that purpose. That is what the statute describes as a protected site. In this case, we say the planning permission provides for houseboats at the West Pontoon, and we say that a houseboat, as properly interpreted, is not a caravan under the relevant, when one considers the relevant legislation and applicable jurisprudence, and the governing planning permission does not provide for a caravan site. The first tier tribunal found that the land is a protected site. I'm going to come back to these terms when we go through the statute shortly. The first tier tribunal found that the land is a protected site and the respondent occupies a caravan as her property. Now, there was some confusion over what the first tier tribunal did, but I don't think we have to worry about that, because the upper tribunal revisited the whole issue, and what the upper tribunal on appeal found was that there is an agreement under which the respondent is allowed to occupy her caravan on the appellant's land, That was the first finding, in essence. The second finding was that the land is a protected site. When I say the land, I mean the small portion of land occupied by the houseboat that you will see shortly is the land that's defined by a 2014 certificate of lawful development. So it's not the whole site; it's a very, very small portion of the marina. And the Upper Tribunal came to that conclusion on the basis that their interpretation of the 1998 planning permission, it provides for a caravan site. And secondly, that it was not a planning permission that was restricted to a holiday use. The Appellant has been given permission to challenge the second finding, if you like, of the Upper Tribunal, that relating to whether the land is a protected site. The Appellant wasn't given permission to challenge the finding that there is an agreement between the Appellant and the respondent by which she occupies her caravan on their land. So we're just looking at really the interpretation of the 1998 planning permission and the effect that the 2014 lawful development certificate has on that planning permission. They're the two key issues, if you like. The Appellant says that properly interpreted, there is no planning permission for a caravan site. The planning permission is for a sui generis use for houseboats, not a sui generis use for caravans. And the houseboat is not a caravan. That shouldn't be in dispute, because that's what the Upper Tribunal found, as the houseboat considered as a whole is not a caravan. I'll take relationships to that in due course. We say the permitted use of the land.
Why can't it be both?
Well, it could be both, provided the houseboat meets the tests that apply to a caravan. So, and the tests, as the course in Carter set out, and I'll come to that also, is it has to be there's two tests: the construction test and the mobility test. And what the Upper Tribunal found, accepted, on the basis of the expert evidence before it, was that the houseboat could not be moved as one. And therefore, it failed the mobility test, and therefore could not be a statutory caravan.
Does that exclude the possibility that the caravan could nevertheless be a statutory caravan? Because, as I understand the facts, the caravan can just be disconnected from the utilities and lifted off and on a ramp and moved.
The caravan itself, the Willoughby caravan, is a caravan.
Yes.
But that's not in dispute. I'm not going to argue that the Willoughby caravan that is placed on the float, I'm not going to suggest that's not a caravan. That is a caravan. But the Appellant's argument is that's not what the planning permission was granted for. The planning permission grants for the whole unit as a single indivisible unit, not its constituent parts. So one has to consider the caravan and the float as one would consider the bricks, the tiles, the bathrooms, the roof of a house, not the constituent parts of a house. You consider the whole. And the planning permission provides for a houseboat, and the Upper Tribunal found that the houseboat was not a caravan because it could not be moved, could not be picked up and moved as a whole. And the statutory requirement for a caravan is you have to be able to move it, tow it, move it as a whole. You can't break it down into its parts and move. That's not a caravan. That's effectively a building.
If I have planning permission for a house and I'm just looking at the roof, haven't I got planning permission for the roof?
Yes, but attached to the house, attached to the structure of the house, so that the planning permission applies to the dwelling house. So planning permission is granted for a dwelling house, and what's expected to be built and completed is a dwelling house in accordance with the plans in its entirety, in its whole, not just one part of it, or the roof on its own. It's the wording of the permission matters. I'm going to come on to caravans, floats and concrete bases, but if you've got a planning permission for a dwelling house, it is for a dwelling house. It's not planning permission to store a pile of bricks on the land in pursuant of constructing a dwelling house.
No, but here the planning permission is for a houseboat, which happens to comprise a caravan.
As part of its constituent part of its constituents that make up make up the whole
No
unit.
different from my lady's example of being a roof of a house.
Well, a planning permission for dwelling house does not provide planning permission to place a roof on land. It provides planning permission to build a house, which will incorporate a roof and incorporate windows, doors, maybe a garage. But it's not planning permission. It's planning permission for the whole, not the parts. Well, I will come back to that. That's the appellant's position, is that the Upper Tribunal considered that the houseboat as a whole was not a caravan. There's no argument that the caravan that is part of the houseboat is a caravan. We say that the permitted use is only for a holiday use. That's what was granted in the 1998 planning permission for a holiday use, and therefore it cannot be a protected site. If the appellant's correct on the first limb of the argument, the second limb doesn't need to be considered. But if the appellant is incorrect on the first limb of the argument, they can still succeed on the second limb. There are wider implications, as I set out in the grounds of my skeleton, in this case, in the context of there are many planning permissions across the country that relate to houseboats on marinas, and they generally aren't considered to be caravan sites, because caravan sites have to be licensed under the Caravan Sites Control Development Act 1960. And not operating a caravan site without a licence is a criminal offence. And there is no caravan site licence on this site, never has been. Nobody's considered it needed one, not the local licensing authority, not the appellant, a landowner. So there are wider implications to this in terms of if we can break down a planning permission to look at the constituent parts of it and say, well, that constituent part on its own can stay alone, despite the fact that a local planning authority could issue a completion notice, forcing a developer to complete the building as granted planning permission, complete the structure.
Can I just make sure I understand your point about that wider implication and how that fits in with the fact that you didn't get permission on ground one? Do you say that's still relevant because it then all depends on the terms of the planning permission, doesn't it?
Yes.
In the sense that your failure to get permission on ground one means you can't say that this isn't a caravan site.
Well, the Upper Tribunal,
Subject only to the planning permission point.
I understand that, but the Upper Tribunal did separate this point out into whether it was looking at.
I'm simply asking about your point about wider implications. The caravan and caravan site point, independent of the planning permission point, that is a ship that sailed, isn't it?
No, my lady. I say that the first element of the Upper Tribunal's determination was there an agreement between the parties that allowed the respondent to station her caravan on the appellant's land, and the Upper Tribunal found that there was, and that's not to be challenged. But the second element for which permission has been granted is the examination of whether it is a protected site, and the grounds clearly go into the interpretive arguments about whether this is a protected site under the Act. So,
But that all depends on the terms of the planning permission,
It does,
which
yes.
will vary between sites. I'm just asking about wider implications.
yeah, it will.
Turn on if you're right, it may turn on the particular terms of the planning
It will.
permission or application.
But the reality is that the significant number of houseboats in the UK are essentially caravans, either on floats or built with floats. So there's still what one would colloquially understand to be, in this case, a Willoughby caravan, but it could be a caravan by one of the other makers.
Well, one
Other
might
manufacturers.
venture to suggest that it would be a rare situation in which the owners of a marina with floating mobile homes would condone the use of or not notice that somebody was using it as their permanent residence in breach of planning permission for over 10 years. And this argument has only come about because of that situation. So I think that the wider implications point really goes nowhere.
I appreciate that in terms of the section, the 2014 Lawful Development Certificate and what's been allowed to carry on. But the interpretation of a planning permission for a houseboat and then how one interprets the 2014 lawful development certificate as granted. They do. The first has a wider implication in respect of the caravan site industry and mobile homes, houseboats that are in marinas, for which planning permission for houseboats has been granted, not a mobile home and a float, but a houseboat, and how one interprets that houseboat. The second element has ramifications for the approach to be taken to lawful development certificates and the certainty that needs to be given to them in terms of the public confidence in what can be taken from what is written on a certificate and how far one can go behind it. And as I'll come to, the authorities generally say, well, the public have to have confidence in what is written on a lawful development certificate, what it is that it provides for, without having to give it some form of different interpretation, which is what I say that the Upper Tribunal did. I mean, this was a certificate that was granted pursuant to section 1911C for a breach of condition, not a material change of use. Now, there are significant differences between the two. And if something that is granted pursuant to 1911C can, on an examination 10 years later, be determined to be granted pursuant to a different provision for a different lawful activity, that then calls into question in my submission the certainty that can be given to lawful development certificates, of which obviously your ladyships know that there are a great many relating to land in the country. So there has to be an element of public confidence in the process.
Mr. Rod, may I ask you what may seem to be a stupid question, please? Could a breach of condition also amount to a material change of use?
Yes, it could.
Thank you.
And I will come to that because obviously your ladyships will have seen the certificate. Your ladyships will also seen the reasons for granting the certificate and the officer's report, which sets out the terms of the application and the terms of the assessment. And I will say in due course that the certificate grants what it grants and it can't be reinterpreted some years later to provide for something else. There was a remedy.
Well, I think it would be helpful in due course.
Yeah, I mean, there's a remedy for
you
that.
To take us through that and explain.
There's a clear remedy, but that remedy's not been exercised.
All right, thank you.
So your ladyships, I'm just going to go. I'll go through the statutory provisions first, just to set out the framework. Then I'll go through the relevant facts.
Yes.
As they apply, and then I'll deal with submissions on those two limbs, if you like, to the one ground of challenge. So if I can start firstly with the Mobile Homes Act 1983. This is what the original application was made pursuant to. You'll find that at page 44 of the authorities bundle. Your ladies will see it, section 1, the particulars of agreements. Section 1.1, this act applies to any agreement under which a person, the occupier, is entitled to station a mobile home on land forming part of a protected site and to occupy the mobile home as his only or main residence. Now, the First Tier Tribunal and the Upper Tribunal have found that the respondent is entitled to occupy caravan or mobile home, the phrase is interchangeable really, on the appellant's land. That is still subject to, there's still a question arises over whether that amounts to a protected site or not. And that's the distinction between the first and second findings of the Upper Tribunal, with only the second finding being challenged, not the first. So that's the provision under which the application is made. You see that there are two requirements: stationing mobile home as part of a protected site and to occupy as a main residence. If I can ask you to turn to section 5, which is on page 59. The interpretation provision, you'll see at the bottom of page 59, mobile home There's the same meaning as caravan has in that part of the Act, and that part of the Act being the Caravan Sites Control the Development Act 1960. Then over the page 60, you'll see, I'm sure your ladyship is familiar, but planning permission, just a permission granted under the Town and Country Planning Act, which I will come back to because it's important, the distinctions are important in there. And then below that, protected site, which is the key issue really, has the same meaning as Part 1 of the Caravan Sites Act 1968. So if we can turn to Part 1 of the Caravan Sites Act 1968, which you'll find at page 15 of the authorities bundle. Section 1, 1.2 is the key provision. For the purposes of this part of the Act, a protected site is any land in respect of which a site licence is required under Part 1 of the Caravan Sites Control the Development Act 1960, or would be so required. And then if we go to the end, there not being land in respect of which the relevant planning permission or site licence is expressed to be granted for a holiday use only. 2A, and 2B is otherwise so expressed or subject to such conditions that there are times of the year when no caravan may be stationed on the land for human habitation. So a protected site cannot be a holiday site, it has to be in effect a permanent residential site, somebody's home. So there can't be an agreement under the Mobile Homes Act to section 1 of that Act if the site in question, land in question, is not a protected site. That is,
the land that we're talking about is simply the small portion of the marina that is covered by the pontoon and the caravan.
Well, I think when it boils down to it, it's actually smaller than that. It's just that the land that's covered by the area that's included in the 2014 certificate. Which is,
are they different?
Yeah, because the planning permission, the 1998 planning permission applies to the pontoon, an area beyond the pontoon, and various mobile home caravans, houseboats stationed on that pontoon. That's the wider 1998 permission. But the land subject to the application relates to that for which the 2014 certificate is granted, which is a subsection, a sub-area of the 1998 permission, but it's only the land that's essentially occupied by the respondent. Which
so
is,
it's the land under the float, essentially.
in essence, yeah, and land around it, but it's not the whole pontoon.
Right. I didn't appreciate that the pontoon had more than one mobile home on it. I had this vision of there being separate pontoons for each caravan, but what you're suggesting is that you've actually got a big pontoon with lots of caravans on it.
Yes. Yeah, and we have some aerial photographs and some marketing photographs, if you like, that taken from the ground that I'm going to come to shortly when I deal with the facts. That will give your ladyships a clear indication of what we're looking at here in real terms. I'm going to come on to the certificate that's been granted, because what we have is a wider. The site itself, the marina site itself, is subject to a number of planning permissions, all of which cover the wider site. We're dealing with one planning permission, which covers one pontoon on the western side of the site, and that's the 98 permission. But there's a small section of that 98 permission which is subject to the 2014 certificate.
Yes.
And the 98 permission, the governing consent for where the respondent stations her houseboat is either the 1998 permission read in conjunction with the 2014 certificate, or the area of the 2014 certificate on its own.
Well, it can't be the latter, it's got to be the former.
Well, the ladyship says that.
Basic planning law.
But the Upper Tribunal found it was the latter. and that the certificate was a standalone certificate under section 1911A, which is for material change of use, and that is the concern of the the appellant. We say that can't be right. The base permission has to be the 98 permission, and that is altered or amended, for want of a better phrase, by the certificate, which declares a breach condition and nothing more, but leaves the permission intact. And I'll come back to this when we're looking at the second element. But the Upper Tribunal did find, and this is the complaint of the appellant, that the 1998 permission can be dispensed with because the certificate is now the governing consent. And indeed, that's what the respondent invites the court.
Well, that I don't have any problem with, but subject to the arguments about it. But at the moment, I don't understand why the consent would have any impact upon the wider planning permission relating to the rest of the pontoon.
It wouldn't. It wouldn't, and it couldn't. It's only in the context of the area to
You're
which the
saying that
certificate
the
applies.
Upper Tribunal has found that it did.
Across the area that the certificate applies, not the whole pontoon. Because really, we're not looking at the whole pontoon. We're only looking at the land, the area occupied by the respondent.
All right. Well, at the moment, I'm a little confused as to what the concern is, but well, you can develop your arguments, and I'll see.
Hopefully, I can dispel that confusion in due
Yes,
course.
yes.
May I ask a question, please, Mr. Rudd? So the definition of protected site in section 1, subsection 2, refers to the relevant planning permission.
Yeah.
Section 16 of the 1968 Act is the interpretation section, and it provides, slightly unusual because it doesn't say unless the context otherwise requires. It says the following expressions have the following meanings. That is to say, planning permission means permission under Part 3 of the 1990 Act. Do you have that?
Yeah.
So the reference to the relevant planning permission, can that include a certificate of lawful use?
I think it can, because section 1917 provides that a certificate under section under section 1911 1A. I will come.
Because there's quite a complicated interaction between all these provisions, and I just wanted to be clear about what you were saying the relevant permission was for the purposes of section 1, 2, and whether it could include a certificate of lawful use, either generally or in this case. And I think what you're going to say is it could include a certificate of lawful use, but only one, which in your case was issued under subsection 1A, is that right?
No. No. Sorry, I should correct that.
No, please do.
Yeah, I don't want to mislead the court.
No.
A certificate under section 191.
Yeah.
By dint of section 1917.
Yeah.
Can be treated as a planning permission.
Yeah.
For the purposes of section 3. 3 of the Caravan Sites Control Development Act, and that is licensing. So if a development, if a caravan site development benefits from a lawful development certificate, although it's not strictly speaking a planning permission, in the true context, it can be treated for that purpose for site licensing rules.
Yeah.
So so when one considers section 191 and the certificates that can be granted, I was going to come to this shortly.
Oh, well, I don't want to interrupt your sequence of events. It's just a point I'm interested in. So.
I can just sow a seed that there are three different types of certificate.
Yes, I've got that.
The first type of certificate for use of land is a certificate that is not parasitic on a planning permission. It's where planning permission doesn't exist and the use has become lawful by the passage of time. So there is no planning permission.
Right.
So in those circumstances, that certificate can act as a planning permission for the purposes of licensing.
Right.
Under section 1911 1C, it's for a breach of condition.
Yep.
It's a certificate declaring a condition is no longer enforceable.
Yep.
You can't have a certificate under section 1911C unless there is an extant planning permission.
No, because it's got to have a condition attached to it.
Exactly.
Yeah.
And that certificate is declaring that the condition is no longer enforceable, but the planning permission remains in place and
Yeah.
remains the governing permission as read with the certificate. So there's no need then to start ferreting around to try and find a planning permission under which you can, a caravan site licence can be granted, because the planning permission remains as it is.
Yeah.
Certificate can be a planning permission, but the practicalities are that it only applies for certificates under section 1911A.
Right. I think I understand that now. I just
Sorry,
wanted
you
to be
said there
clear
were
about that.
3
You haven't
times.
got to the third,
I
which
think
is
there's only 2.
Sorry, I skipped
change
the
of
second.
use.
I skipped the second. The first is a change of use of so section 1911A is a change of use of land or of a building. It becomes immune from enforcement because it's been used for 10 or 4 or now 10, with the change in the rules this year, 10 years. 1911B is for operational development, building operations. If I build a granny annex in my back garden, provided it's been there for the requisite period of time, it becomes lawful. It's a building. It's not something that we're going to be concerned with over caravan site licensing, which is, forgive me, it's why I skipped it. The first one's 1911A is relevant,
Yeah.
and 1911C, which is breach condition, is relevant, but 1911.
I thought the 3 that you were coming up with was one where there's no planning permission at all.
Yeah.
Change of use can apply to a situation where you've got planning permission for use for one purpose and then it's changed to another purpose.
It can.
Yes.
So yeah.
So you have got 3 effectively. You've got a situation where the land's got no planning permission at all and a certificate is given because it's been used for a particular purpose without planning permission for 10 years plus.
Or presumably building without.
Or building without,
permission.
yes, exactly.
So it's use or building.
Yeah.
That's one category. Then you've got change of use, where there may 1A, where there may be a previous planning.
1911A is, perhaps if we turn to it, it's on page 72.
Yeah.
So section 191, certificate of lawfulness of existing use or development, Standard Country Planning Act 1990. So 1911(1), if any person wishes to ascertain whether A, any existing use of buildings or other land is lawful. Now that, as your ladyship rightly points out, that relates to land or buildings which may have a lawful use flowing from a earlier planning permission, but the activity that's going on that land or in that building is not related to that earlier planning permission and has been going on for the required period of time to achieve immunity in terms of use. So in essence, the earlier planning permission's an irrelevance.
Yes, there may or may not be an earlier planning permission, but what's being done was not previously authorised.
That's right. So in effect, what you have is a certificate which declares the lawfulness of the use of the land or the use of the building that's unrelated to a previous permission and therefore is a standalone certificate. That is the consent that governs the use of the land or the building, that certificate alone.
Okay.
And one can disregard the previous planning permission, but it has no bearing on the use of the building or land moving forward.
You say in your 191C scenario, this must be right, there must be a previous planning permission.
There must be, Your Ladyship, because it said any other matter constituting a failure to comply with any condition or limitation subject to which planning permission has been granted is lawful.
Well, I understand that, but I don't quite at the moment get the further, what looks to me like a further leap when you try and interpret 1917.
Under the Caravan Site Licensing, the Caravan Sites and Control Development Act 1960, to operate a caravan site, one has to have a caravan site licence. And a caravan site licence can only be granted if there is planning permission in the words of the Act, planning permission for use of the land for that purpose. Now, under 1911C, 1A, if I put caravans on land for 10 years and I obtain a certificate for that use under 1911A, there is no planning permission for that use. There is only a certificate telling me it can't be enforced against because it's immune from enforcement. But there isn't a statutory planning permission granted for that use. So what the Act has recognised, the Town and Country Planning Act recognises at Section 7, is that in those circumstances, although there is no formal planning permission, the use of the land as a caravan site is lawful, as declared by the certificate, which would be under Section 1911A. And for the purposes of the Town and Country Planning Act, that is to be treated as a planning permission when considering licensing. So if I have a land upon which I put a caravan for 10 years and it's declared to be lawful in the sense it can't be enforced against, I can then rely on that certificate that's granted under Section 191 to obtain a caravan site licence such that I'm not committing a criminal offence.
Okay, but I think you say that subsection 7 can't apply in relation to subsection 1C.
No, it wouldn't, because subsection 1C in essence would be an existing permission, planning permission, for which there's been a breach of condition. Now, a caravan site, a mobile home park, however one wants to describe it, is a sui generis use, i.e. it's a use in its own right. So there has to be a planning permission for that use. Now, that planning permission might be conditioned to say only 10 caravans or only a holiday use. And one of those conditions may be breached, or only touring caravans. That condition might be breached, for which I receive a declaration of lawfulness that the condition can no longer be enforced. But I'm still left with the base planning permission for use as a caravan site. What I can't do is obtain a certificate for breach condition, which provides in its own right for a caravan site that isn't already provided for. There's no mechanism to change the description development that's provided for. I'll come on to this because this is a matter that Lord Justice Lindblom dealt with in Barton Park Estates, when one changes a condition, removes a condition or adds a condition, you can't change the base permission. What's been granted planning permission is what is granted planning permission. You can't then alter the substance of that. So under Section 191, a certificate under Section 1911C, there must be a planning permission. It must be a planning permission for a caravan site. I may breach a condition on that permission, which gives me a certificate that allows me not to operate that caravan site in accordance with that condition anymore, but it's still a caravan site. So under the site licensing provisions, I'm still relying on the base permission to obtain a site license. I'm not relying on the certificate that's granted.
Doesn't that depend on what the planning permission actually relates to?
Well, it would have to, yes, it does.
Because if let's suppose 1911C, it's any other matter, which I read as being something other than existing use, constituting a failure to comply with any conditional limitation subject to which planning permission has been granted. So planning permission may have been granted for something other than a caravan site.
It may have been, but if I use that land as a caravan site, that is a Section 1911A application because it's a change of use. Because a caravan site use is a sui generis use. It doesn't fall under any of the use classes. So I can't switch between similar uses. It has to be planning permission for a caravan site or a mobile home park. If I use it for some other purpose, if I have a planning permission for the keeping of horses, an equestrian venture, and I put caravans on the site, although there is a planning permission for an equestrian activity, the use of the land is a different use. It's a caravan site use, and therefore Section 1911A applies, not 1C. So I'm not breaching a condition of the permission, the extant permission. I've introduced an entirely new use. I hope that assists. which is why I say that in essence, the provision under section 19117 does, in practical terms, is only ever engaged where there's a new use introduced under the certificate granted.
Okay, so just to help me, 7A refers to section 3.3.
Yeah.
That's not dealing with protected sites, that's dealing with caravan.
That's dealing with caravan site licensing.
Caravan site
But obviously,
licence.
a protected site is a site that requires a license.
And so is your point, one of your points, that the 1998 permission was the permission that gave permission for a caravan site?
No, but my point is that the 1998 permission gave permission to use the land, the whole of the West Pontoon, as for the stationing of houseboats.
Well, yes, but given ground one of the appeal, you haven't got permission on it, is for the stationing of caravan.
Ground one relates to the agreement
Okay.
that
Right.
has been. There is an agreement which allows caravans to be stationed. Ground two is the examination with the protected site.
Mm.
And
Well,
I'm addressing.
if the original permission is not for use for a caravan site at all, right? Let's assume that's right for the moment. It's only for something else. Then what we have is an agreement that part of it can be used for a caravan, and you've got a certificate which you say is granted on the wrong section. But
No, I
in
don't- no.
substance, it's granted for the use of the buildings for which there is no permission.
No, that's the contrary to my argument. I say there's an agreement whereby the respondent can live in a caravan.
Mm-hmm.
We say that's effectively the mooring agreement. But she is living in a caravan, Willoughby caravan. I say that the planning permission that's been granted is the 1998 permission, relates to use of land, which is the use of land for the stationing of houseboats, and that the 2014 certificate relates only and exclusively to breach of condition under section 1911C.
Just answer, please, this question, because now I'm not following the argument. It's my fault, I'm sure. As I understand it, you need some kind of authorisation, whether by planning permission or under 19117, if you're going to allow anybody to operate to live on a caravan on your land, correct?
Lawfully, yes.
Yes. So by what means then can the respondent lawfully occupy your land pursuant to the agreement that she's entered into with you to live in a caravan?
Lawfully, she can't, because there is no planning permission for that purpose. Well, we can enter into an agreement with her to moor her houseboat at the West Pontoon.
So the agreement isn't worth the paper it's written on?
Well, it's an agreement that allows her to live in the caravan on the float at the West Pontoon. I mean, it's clearly has to have some effect, and it's under that agreement that notice to quit was provided, which
Well, you
resulted
can't have it both ways. Either she's lawfully in occupation on the land or she's not. But you've entered into an agreement with her, and presumably under the statutes, you can't have a situation where you've entered into an agreement, which is an enforceable agreement, but you haven't in some way, you say, any basis for lawfully allowing her to do that.
No, we can lawfully allow her to moor her houseboat, as we do many other people on the marina, to moor her houseboat. What we don't accept is that the planning permission provides for a caravan site. They're two different issues. The respondent moors her and has moored her houseboat, which we say is not a caravan. So we're not agreeing that the unit in its entirety, albeit she lives in a caravan which is part of the houseboat.
Mm.
We accept that there is an agreement for her to moor her houseboat, as with a standard mooring agreement. I'll take your ladieships to it shortly. standard mooring agreement. But the planning permission doesn't provide for this land to be treated as a caravan site, to be a lawful caravan site. It is a sui generis houseboat, pontoon and houseboat site, a marina, not a caravan site, and that's the issue.
Right.
If the certificate, the 2014 certificate, was granted under section 1911A, as was found by the Upper Tribunal, then that becomes the governing consent. And that's where section 1917 is engaged, because the governing consent, the tribunal say, was when one interprets the certificate for a caravan site. If it was granted pursuant to section 1911C, i.e. a breach of condition, which we say it was, one still has to look at the 1998 permission, because that is the planning permission, not the certificate. You don't need to rely on 1917.
Well, you say you don't need to, but what's to stop 1917 applying?
Because,
I mean, nothing, just
Yeah.
help me, because 1917 contains no limitation that says this applies to 191A and B, but not to C. So there's a gap in the reasoning that I haven't quite.
because a certificate under 1911C does not provide for anything other than a declaration of a breach of condition. There has to be a parent planning permission.
Yes, I understand what you're saying, but there's still a sort of jump in the reasoning from there to saying that 1917 has no application. On the face of it, and I'm not a planning expert, so please correct me, 1917 just talks about a certificate under this section.
On the face of the Act, it could have that effect. You could treat a certificate under 1911C as a planning permission. But the problem with that is, without taking the very basis of a certificate under section 1911C is there has to be a planning permission in the background for which a condition has been breached.
Well, therefore, you have to say that Parliament obviously, in order to interpret subsection 7 as only applying to grants under A, possibly B, you have to say that Parliament's intention is in some way restricted to circumstances where there was no planning permission before. And on the face of it, as my lady says, it talks about a certificate under this section shall have effect for the purposes of these enactments as if it were a grant of planning permission. Why doesn't that mean what it says? In other words, you treat it as if it were the necessary grant of planning permission under those enactments that would be necessary for the purposes of those enactments, even if the extant planning permission is not extending to those enactments.
Yeah, I understand what your ladyship's saying. Could I ask your ladyship to turn to page 76, please?
Yes.
And this is section 193. You see under section 193(5), a certificate under section 191 or 192 shall not affect any matter constituting a failure to comply with any condition or limitation subject to which planning permission has been granted, unless the matter is described in the certificate. Now, this was the subject of litigation in the Adams case, Mrs. Justice Laing, which I will come to in due course. If there's an extant planning permission and it contains 10 conditions, and I receive a certificate under section 1911C declaring that condition 1 is no longer enforceable because I've breached it for 10 years, the planning permission is still the governing permission, and the other conditions that have not been breached, for which there is no certificate, remain extant. That's the effect of 1935.
Yes.
We can't treat the certificate under section 1911C as a standalone planning permission because it doesn't have that effect. It is merely a declaration that a condition has been breached and is no longer enforceable.
But it may have effect in relation to that condition. And there are different sorts of conditions, even I know this, that some may relate to use, as this does. Some may relate to, I don't know, the colour of the tiles on the house or whatever it is. Where it is.
But the condition is controlling something. So you have a planning permission is granted on an application for a description of development. It's granted with the description saying you can do this. This is what you can do with your land. And then conditions are imposed to say this is how we control the use. And the use, they may be various, as your ladyship says, it might be the colour of the tiles or the height of walls, etc. If a certificate is granted under 191C because one of those conditions has been breached, it's not providing me with a permission to do anything. It's merely saying that I don't have to do what that condition says. What I'm granted planning permission
It depends on what the condition is. Sorry, that's not right. If the condition is you won't live there more than 6 months in a year, and you get that condition knocked out after 10 years by a certificate of lawful use, you're allowed to live there the whole year round.
I am, but only in the development, the residential development that is provided for by the permission.
That's a different point.
Well, that's what links section 1917 with 1911A and 1C. There has to be a base permission. A 191 certificate subject to 1911C cannot provide for a standalone use. The use has to be, because the very wording of 191C is subject to which planning permission has been granted.
But you accept that the respondent, with the benefit of the 2014 certificate, can in fact live there all the year round.
Yes.
And that is the effect of the certificate.
Well, the certificate, the effect certificate is that wouldn't be a breach of condition, living there all year round, because the certificate declares it not to be a breach of condition.
So then it can't be enforced against.
Can't be enforced against as a breach of condition,
Yeah.
but it may not be provided for by the planning permission.
Yeah.
And therein lies the crux. The planning permission is for a holiday use only. Houseboats for holiday purposes. There is an ambiguity in the certificate. There is an oddity about it. I accept that, and which has to be resolved. The Upper Tribunal resolved it on the basis that regardless of what was sought and what was assessed and what was granted, it should be treated as a certificate for use. Whereas I say that applying the relevant jurisprudence and the requirement for certainty in certificates, it provides for a breach of condition, nothing more.
Can I put it this way, just to see if I've understood your point? You say the certificate effectively provides a defence because it can't be said that the occupation is in breach of condition, but it doesn't provide a positive permission.
That's right.
Is that a fair summary? But whether that's true may depend on whether you're right on the interpretation of the scope of 191.
No, because 1917 applies to site licensing. It's whether or not whether I can apply for a caravan site license or not. The scope of the declaration of lawfulness is enclosed, is provided for at section 1911 itself. The three mechanisms of declaring lawfulness. Either I've got a use of land or buildings that's lawful, because it can't be enforced against. But that's not providing me consent to do it. It is saying that it can't be enforced against, and there's an important difference, and that I will come to the authority.
The reason I've asked, put the way as I put it as I did, is I thought you accepted earlier that if it was 1911A, then you wouldn't succeed on this point, and 1917 would apply. But I'm not sure that
I do accept that.
But then all 1917 does is apply in respect of section 3.3. So I don't think I followed you.
I mean, I wasn't going to go to section 1911, section 1917, because I don't think it's relevant to the interpretation certificate. It's relevant to whether a caravan site licence can be granted or not. There's no issue in this case. A caravan site licence can be granted if the planning permission provides for a protected site. You don't need to
Do
go
you
to.
accept that the respondent could have got a certificate of use under 1911A?
Do I accept that she could?
Yes.
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 And that is what I was alluding to when I
So,
said that.
so on your case, she's simply gone under the wrong section.
Yes. But the point there is, I alluded earlier to, there is a remedy to this. I have to accept that. But the point is that there has to be, the public have to be capable of placing reliance upon what a certificate says, what has been granted. It might be that something else could or would be granted.
So even if the substance of what's being granted is exactly the same, you say that you've actually got to jump through a particular statutory hurdle in order to achieve what you want to achieve.
Well, there is a statutory code which provides for and provides local planning authorities with the power to grant certificates. And if an application is made pursuant to one section and granted pursuant to assessed pursuant to that section and granted pursuant to that section, that's what that certificate provides for. It might be that something else could be achieved, and I accept in this case, as I have to, that it could be achieved.
Can I ask a question about the relationship, please, between subsections 6 and 7 of section 191? Subsection 6 refers to the lawfulness of any use, operation, or other matter, which appears to reflect the three limbs of section 191, subsection 1.
Yep.
Is it significant that subsection 7 only refers to a certificate in respect of any use? Because, I mean, on the face of it, there is a difference, and I don't know whether you think that you submit that difference is significant or not.
Well, I think it probably is significant because it leads into what I've described as a practical effect of subsection 7, in that it relates to a use because there has to be a permitted use as a caravan site, and to obtain a permitted use as a caravan site, there are two routes. One is the grant of express planning permission under the 1990 Act. The second is to use land for that purpose for a requisite period of time, 10 years, and gain a certificate under section 1911A. And the point of subsection 6 is going back to, if a certificate is granted on an application, what is set out in that certificate, and it has to be considered as a whole, not in individual bits and not subdivided, considered as a whole. And that was where I fell foul in submissions in the Adams case in trying to subdivide a certificate up. What that certificate provides for, whether it's a use, a building operation, or a other matter, such as a breach of condition, has to be conclusively presumed to be lawful. One doesn't go behind it and try and reinterpret it to try and dissect it and see what it means, what it does actually provide. But it provides for what it says. That's what it says on the tin.
Yeah.
That's the point of subsection 6. It's to provide certainty. So when somebody comes along 15 years after a certificate has been granted, they're not having to scratch their head
No,
as
I
to what it means.
understand that. But the question I was asking was a slightly different question. It's about how you construe the two provisions when they're set against each other, because and it may not matter, but subsection 6 refers to all three limbs of section 191, subsection 1, whereas subsection 7 only refers to a use. What I'm asking you is whether that difference is significant or has any effect on how we should read subsection 7.
Well, it must, because under subsection 1B, any operations which have been carried out in, on, over, or under land are lawful. They're building operations. A caravan site is a use of land. Caravan has to remain mobile to meet the mobility test, so it can't be a building, it can't be a building operation, it has to be use of land. So you're never going to get a caravan site licence for something that is a building.
Yeah.
So when it talks about Caravan Sites Control Development Act the licensing provisions in the Mobile Homes Act Wales, that can only be, a certificate can only be granted for a use.
Yeah.
Caravan site license, sorry, for a use. So there is relevance.
So in other words, it's use as a caravan site, and it's got nothing to do with holidays only or for residential purposes. Is that the point?
Well, ultimately it does, because the licensing regime is different for holiday and residential purposes, etc. Under the Caravan Sites Control and Development Act, there has to be a planning permission to grant a caravan site licence. That planning permission might not be an express grant. It might be a certificate under section 1911A.
Yeah.
For a use of land. It can't be a building, because that's not a caravan site. It has to be the use of land. So it does, in my submission, follow that, although it doesn't expressly say that, in explicit terms, if you like, that the subsection 7 only applies to subsection 7A only applies to a certificate under subsection 1A. It must follow that is the only provision which provides for a use. Caravan site being a use of land.
Because the point I'm trying to understand is there any significance in the fact that subsection 6 refers to all 3 limbs, whereas subsection 7 only refers to 1 limb?
Well, there must be, because subsection 6 refers to the 3 limbs under which certificate can be granted.
Yeah.
Subsection 7 refers to one limb.
Yeah, all right.
Which I suppose is an easy way of demonstrating the practical outcome of what subsection 7. I suspect I rather went around the houses to try and demonstrate that, but it can only actually have effect where there is a use of land, which has to flow from an extant permission. And such that if you have a certificate under section 1911C, because that is parasitic on an extant permission, that extant planning permission must provide for caravan sites, so subsection 7 wouldn't need to have any effect, it wouldn't need to be relied upon.
My lady's already made this observation, but I just wanted to ask you again, going back to 1911, any other matter in C might suggest that the matters in question are things other than existing use and operations.
Yeah.
But if that's the case, does that not somewhat undermine your argument? Because what this particular condition is all about is use.
The condition doesn't provide a positive consent to do something. The planning permission, the description of developments in the planning permission, and this is something that Lord Justice Sullivan dealt with in case of Wall and Winchester, so I'll take your leaderships to shortly, and relying on Mr. Justice Hickinbottom in the case of Cotswold Grange. And this was a formulation that was approved by this court in the case of Finney. A planning permission, the description of a planning permission, words in the description provide what a building can be used for, and the conditions control that use. They prohibit, if you like. One is permissive, one is prohibiting. So by declaring that a condition is no longer enforceable, it doesn't provide for any positive, any additional use, any additional activity or planning benefit that is not already provided for by the description of development, if you like. The description of development remains and must remain unaffected. I will take your leaderships to where Mr. Justice Lindbaum, Lord Justice Lindbaum said that in the Barton Parks Estate case. So you can strip conditions out of a planning permission which control how the use is undertaken, but the base use remains as it is, what it provides for. And it's important that it provides only for what it says. So in this case, you have a planning permission for the use of houseboats for holiday purposes.
And you say that's still in place?
Yeah. Now the condition is the way in which that was controlled. So the condition says, planning permission says you can use this land for houseboats for holiday purposes. The condition says you can only use it for holiday purposes and not as a main residence. And there's two mechanisms of breaching planning control. One is to breach condition, a condition that's in place, and the other is to, in this case, the other is to do something for which planning permission has not been granted. Now, in this case, the Section 191 certificate strips out the condition. And I say that's under 191(1)(c) because that's what was sought and that's what was considered, and I say that's what was granted. But it leaves the description of development intact.
To me, that sounds like amounting to saying that she can't live there all the year round because the substantive planning permission, before you get to the conditions, refers to holiday use, and that can't be.
But
you accept that she can live there all.
I accept she can and not be in breach of condition. I don't accept she can and not be in breach of planning control. The two things are different. Because a breach of planning control, as I said, can amount to either being in breach of condition or doing something for which you don't have planning permission.
Okay, so you say she hasn't got planning permission to live there this year, but she is not in breach of a condition.
It's slightly more nuanced than that. The planning permission provides for holiday use only. The condition says you can't use it for anything other than holiday use, and you can't use it as your sole or main residence. She has been doing that. That's accepted. It was accepted by the local authority, and the condition was removed. Whether that is in breach of planning control will depend on interpretation of the permission, because the description of development is not changed. It can't be changed. That's fundamental. So then it's not about all year round use. It's about the nature of the use. So one could, in theory, live all year round or use the houseboat all year round for holiday purposes, which would be provided for by the permission.
That's Darcy on Pinhead. She lives there.
Well, it's an argument that's often used when interpreting permissions.
So, Mr. Rod, could the local planning authority enforce against the breach of the planning permission?
I say yes, because the planning permission provides for holiday use. The only way they couldn't enforce is if that certificate, Section 191 certificate, is declaring a new use. Because as it stands, if it doesn't declare a new use under 191(1)(a), subsection 1(a), then all
I think you're going to need to show us some pretty strong authority for that proposition.
Well, I will come to that.
But well, perhaps we'd better move on and let you develop your arguments.
So I think before we went on to the 191, Section 1, we were looking at the Caravan Sites Act 1968.
Yes.
Section 1 and subsection 1. Section 1, sorry, subsection 2. If we can look at page 1, please, the Caravan Site Control Development Act, just to fill the gap, if you like. So this is, I've referred previously to prohibition of use of land on caravan site, section 1. Subsection 1, subject to provisions as part of the Act, no occupier of land shall, after the commencement of this Act, cause or permit any part of the land to be used as a caravan site unless he is the holder of a site licence for the time being in force as respects the land so used. You see subsection 4. In this part of the Act, the expression caravan site means land on which a caravan is stationed for the purposes of human habitation, and land which is used in conjunction with the land on which a caravan is stationed. So if this planning permission provides for a caravan site, then a licence is required under section 1.
So if the planning permission on its proper interpretation provides for land on which a caravan is stationed for the purposes of human habitation, and land used in connection with land on which a caravan is so stationed, then you need a caravan site licence.
Yes. Let's turn to the Town and Country Planning Act. It's page 64 of the authorities. So planning permission is required for carrying out development, and development is defined in section 55. 55(1). Subject to following provisions of this section, this Act, except where the context otherwise requires development. That means the carrying out of building, engineering, mining, or other operations in, over, or under land. So there's the first limb, if you like, it's building operations, or the making of any material change in the use of any buildings or other land. So the two types of development, operational development, I'll call it, as in building activities, and the use of land, just using it for horses, stationing caravans, storing materials on it. So there's two limbs there, and that in my submission is important when one comes to considering the planning permission. If I could ask you to turn over the page to section 73A, it's page 67. Section 73A, on an application made to a local planning authority, the planning permission which may be granted includes planning permission to development carried out before the date of the application. It is accepted in this case that the 1998 permission was effectively a retrospective permission. The development had already been carried out, and the permission refers to retention of. So there's no dispute there. That there is some problem with the documents that can be located for that permission. I'll come back to that shortly. We've got the permission itself, but nothing in the way of plans, etc. But it is a retrospective permission applying to what was there at the date of the application. And I don't think there's any dispute between the parties that what has remained is what was granted planning permission. And then we've dealt with the section 191. Section 191 matters that I wanted to deal with. Other than your ladyship's will see under section 191, subsection 4 says if on an and this is page 73. Sorry, if on an application under this section, the local planning authority are provided with information satisfying that the lawfulness at the time of the application, the use, operations, or other matter described in the application. So that and I place reliance on this. It's described in the application. Well, that description is modified by the local planning authority, or the description substituted by them. They shall issue a certificate to that effect. And, subsection 5, and this is important to the interpretation.
So where are you reading from?
Sorry, page 73, your ladyship.
Yeah.
And it's subsection 5, 4 and 5 of section 191.
Yes, thank you.
So subsection 4 provides the power to the local authority to issue a certificate in respect of the application that was made, and then subsection 5 sets out what a certificate must contain. It must specify 5A, specify the land to which it relates. 5B, describe the use, operations, or other matter in question. 5C, give reasons. And I'm going to place reliance on that requirement to give reasons. It's a statutory requirement, so the reasons that are contained in a certificate cannot be ignored. And then specify the date. I'm going to, in due course, place reliance on that statutory requirement to give reasons for granting a certificate.
Wait, before you refer to subsection 2 and 3 while we're there.
My friend just asked me to point out subsections 2 and 3. Save him coming back to it, I presume. Section 2 is for the purposes of this Act, uses and operations are lawful at any time if no enforcement action may be taken in respect of them. They do not constitute a contravention of any of the requirements of any enforcement notice then in force. And subsection 3 is for the purposes of this Act, any matter constituting a failure to comply with any condition or limitation subject to which planning permission has been granted is lawful at any time if the time for taking enforcement action in respect of this failure has then expired and it does not constitute a contravention of any of the requirements of any enforcement notice and breach condition or breach condition notice then in force. So I wasn't going to take your ladyship's to any further statutory provisions at this stage. I hope that set out the framework under which the relevant facts and issues need to be considered. My lady friend may have some additional provisions to take you to in due course.
Yes.
If I can turn to the facts of the case and ask your ladyships to turn to page 381 of the volume 2. This is an aerial photograph of the majority of the marina owned and run by the appellant, and you'll see the area outlined in red. Hopefully you have a colour copy to the top of the page or the left of the page looking at landscape. That's the west pontoon. So that's the pontoon to which the 1998 permission applies. And you'll see at the end of the pontoon there are, as you come along the pontoon, there are regular houseboats either side of the pontoon jutting out into the marina. And at the very end there are 3. 2 at an angle and 1 sticking out as a continuation of the pontoon. That is the unit. It's Miss Jaffe's houseboat. That's the one there.
The one in the middle, is it?
The one in the middle of the 3 at the end, yes. And that essentially, and as we'll see from the certificate, that and some of the water around it is the land that we're concerned with. So you can see from that photograph that the site is largely, in terms of the marina, largely a variety of different types of houseboats moored on pontoons into the marina and moored on pontoons around the outside of the marina. If I can ask you to turn to page 346, this gives a bit more of a flavour, if you like, of what's going on the site.
These bundles are incredibly difficult to navigate one's way around because you've got full lots of hole punches. And
Yes, you're quite right, ladies. If I had that difficulty, I'd have to put mine into a 2-hole, I'm afraid.
yeah, I think I might have to do the same.
I do apologise. It holds the documents more securely, but makes them more difficult to access.
Yeah. Yes, 346.
It's
That's a brochure.
It's a brochure for the marina, but it contains some aerial photographs, so one gets a sort of a 3D view of what's going on. And at page 347, you'll see the bottom of the picture at the top. At the bottom there, you see the west pontoon jutting out into the marina. and the respondent's houseboat at the very end of that pontoon.
So at the bottom of the picture on page 347.
Yeah.
See, there's a separate caravan park on the.
There are, I think, there are touring caravans that are located on parts. That's why I say the marina itself. There's a variety of permissions for
Yes.
houseboats, touring caravan. There's a leisure facilities, amenities for the residents of the users of the marina. It's a variety of planning permissions. It's been in existence for some years, and as with all of these sorts of sites, it's just been generally developed. Yeah, as you go through the brochure, you'll see on 348 there's a description of the marina itself, and it gives a flavour to it. There it's the berths and the other facilities, touring caravan park, slipway, fuel sales, and marina buildings, there's residential flat. It's a varied site, if you like. 349, you'll see there further photograph, and then at the bottom of the page a plan, and the Christmas tree-like pontoon sticking out from the left-hand side. The western side is the west pontoon that we've already looked at. And then 350 talks about the business, and 351 you'll see a further picture of the pontoon. So the marina itself, as I've already said, is owned and run by Tingdene Marinas Ltd, the appellant, and there's a variety of forms of occupation, but in this case, the respondent, she owns a houseboat and she lives in a houseboat, and that's the extent of ownership. And the pontoon itself, which services the houseboat, is owned by the appellant. As I said earlier, there is a mooring agreement which the appellant considers to be in place. You'll see that page 371. That's an agreement between the appellant and the respondent. Address is 8 West Pontoon. You'll see at the end there, Schedule A, name of vessel, houseboat 8 West. That is in essence the agreement that is in place, and over the page of 372, etc., you have the various terms attached to the mooring agreement. And what prompted this application, the application for the Mobile Homes Act agreement, was a notice to quit that was served by the appellant on the respondent to quit the berth, if you like, quit the pontoon.
Under the terms of this document,
Yeah.
presumably.
Yeah. And
So is the notice to quit in the bundle?
I don't think it is actually. It's not, I'm afraid. That obviously, in due course, if appropriate, will be subject to other litigation. I suspect that there was a notice to quit for various reasons, which are not relevant. And then, because there is no security of tenure under the mooring agreement, the respondent then sought an agreement under the Mobile Homes Act to understandably secure some security of tenure. If I can now, just in terms of facts, deal with the development planning documents. And there were 2, as we've already dealt with, the 1998 permission and the 2014 certificate. The 1998 permission is at page 379. Your ladyships will see it's to Mr. B. Berry, Huntingdonshire District Council, in pursuant to powers under the above mentioned Act, hereby grants permission for, and this is the description development for which planning permission is granted.
15 houseboats for holiday use.
Yeah, well, it's the retention of use, and that's important because not operational developments, as I've already pointed out, there are two forms of development.
Yeah, and this is retroactive.
Yeah, it's a retrospective permission for the use of land, not operational development,
Yes.
for 15 houseboats for holiday use.
Yes.
And then there's moorings, parking, and ancillary development, which is going to, by its very nature, going to be operational development. So
And
this
it's
is
subject to full conditions.
yeah, but it is important, and I'm going to come back to it, that the permission is for use of land.
Yeah.
And the part of the permission that relates to the houseboat is for use only, not operational development. And it's subject to conditions, and you'll see condition 1, which is the condition that is the relevant condition for the certificate, subsequent certificate. Houseboats hereby approved shall be used only as holiday accommodation, shall not be used as the sole or main residence of any person. And you'll see at the bottom of the page there, the reason for imposing that condition is to enable the local planning authority to control the development in an area where permanent residential accommodation would not normally be appropriate. And it's always relevant when considering conditions to consider the reason for imposing that. The permission itself references plans, drawings and documents which form part of the application. And it's trite law that where they're referred to in the permission, they can be considered to interpret the permission. It's not something we need to trouble ourselves with here, but in any event, we don't have them. This is some of the problems with historical planning documents is they go missing. What we do have is at page 384. Is a UK patent application for the float. Now that's dated, you'll see there on the left-hand side at the top, May 1994, which was 4 years before the grant of planning permission. It's not known whether this document was incorporated as part of the planning application, but I think the parties accept, as a matter of common sense, given that the planning permission was a retrospective permission relating to houseboats, which incorporated this float at Hartford Marina, and the application was made, the patent application you can see there was made by Hartford Marina Ltd. I think it's fair to assume that this patent application does give an indication of what the float and caravan arrangement is.
So, instant conversion of a caravan into a houseboat.
Yeah. Plainly, the caravan can't survive on the water on its own. It needs some kind of flotation device. This has been created to facilitate, if you like, the making of a houseboat. And in terms of the retrospective application, we say, and I think the respondent says that this is what the retrospective application related to, was the Willoughby caravan that we've seen in some of the photographs, put on this float, and then the whole thing together treated as the Hartford houseboat, if you like.
Mm.
So can't be sure that this is incorporated into the permission, but it's reasonable to draw an inference from it that this is what the development related to.
Did the Upper Tribunal, the first tier tribunal, make any relevant findings on this point?
I'm not sure they did, but it was put to the Upper Tribunal that there was any dispute between the parties that reliance could be placed on this document when considering the structure, the houseboat itself, and how one considers the houseboat. you see at page 383, there are elevations and floor plans for a houseboat. That's dated 2012. It plainly wasn't before the council when they were considering the 1998 application. So I suppose what we're trying to do is we've got a description developed that sets out houseboats and trying to give effect to what that might actually relate to, and that the patent application would be a fair indication of what was built, and therefore what the 1998 permission related to, because it was already present. So what we have in effect is houseboats that were granted planning permission comprise the float as set out in this patent application, extensive flotation devices bolted together with various beams and structures, caravans put on top of the flotation device, the float, boardings put onto the float so that it's accessible from the caravan's accessible from the pontoon, various railings and paraphernalia, and it's all of that as a single unit. I say is the houseboat. I say that's what was granted planning permission, not the caravan, and equally not the float on its own. The houseboat as a unit. It's easy to focus on the caravan in this case and say, well, we're just going to look at that caravan, but anything that is argued about the caravan and what can be done with that equally applies to what can be done with the float.
You can't live on the float on its own, can you?
No, but the planning permission provides for a houseboat, and the houseboat is the entire structure, not its constituent parts. So under the Town and Country Planning Act, if I gain a planning permission for a dwelling house, and I just build the garage, there is a power for a local authority to issue a completion notice requiring me to build out the planning permission as a dwelling house. It doesn't give me permission to part build. It gives me permission to build and use as granted. So that's the planning permission, and that's as much as we have really.
Doesn't mean that you don't have planning permission for the garage once you've constructed the whole.
No, that's right. But the whole has to, if the planning permission is for the whole, but not just the constituent parts alone. And I'll come back to this, but the argument seems to be that in some way the caravan is placed on the land, but it's not. It's the houseboat that's placed on the land. The houseboat from which planning permission was granted, it was the change of use to allow houseboats to be placed on the land. That planning permission would not provide for the caravan itself on its own to be placed on the land, and the Upper Tribunal was satisfied
because
with
it
that.
would sink.
Well, let me take an extreme example: the marina being drained, and the caravan being placed on the land beneath at that point on the pontoon. The caravan doesn't have planning permission on its own to be placed on the land, and that wasn't in dispute, and the Upper Tribunal were happy to accept that. I will come to the Upper Tribunal just listening about it. It's the as a whole, not the constituent parts. You could turn to page 354, please.
That's the key document, isn't it?
Yeah, this is the
It says that the use was lawful.
2014 certificate. Your Ladyships will see granted 6th of June 2014 at the bottom. The first schedule, as your Ladyships pointed out, certificate of lawful use as existing for occupation as a sole residence. Then you'll see in the paragraphs at the header, in the heading at the top of the certificate, there's the address, person to whom it's granted, and Huntingdon District Council hereby certify on 23rd of April 2013 the use described in the first schedule to certificate in respect of the land as specified in the second schedule of this certificate and edged in red on the plan attached was lawful within the meaning of section 191 of the 1990 Act. And then the reasons that are given, which must be given according to the statute, On the balance of probability, the evidence submitted with the application has demonstrated that the accommodation has been occupied continuously for sole or main residence in breach of condition 1, the planning permission, etc., that's 98 permission, for a period of more than 10 years prior to the date of the application. And I accept, and I must, that there is a contradiction, an ambiguity between what's contained in the first schedule and what's contained in the reasons.
No, there isn't. Sorry, where's the contradiction? The reasons are that the use, which is now certified to be lawful, is deemed to be lawful because, notwithstanding that it wasn't allowed by the original permission, it has now been done for 10 years without permission, and therefore it's lawful.
The reason says on the balance probability, the evidence submitted with the application has demonstrated that the accommodations have been occupied continuously
As a sole or main residence, that's its
breach of
use.
condition.
Yes, but that doesn't matter. What it says, the use, which is now deemed to be lawful, is the occupation continuously as a sole or main residence. And the fact that it has been in breach for more than 10 years is the reason why you can't now say that's unlawful.
The reason that's given is that the condition has been breached. And that, I say, is the manner in which the application was considered. And I place, if I've asked your ladyship to turn over, well, firstly to page 356. You'll see the familiar West Pontoon, and you'll see that the area outlined in red is the area to which the certificate applies. So it's only houseboat 8 and the land, if you area of the marina associated with that, if you like, presumably for berthing a boat. And then if I ask your ladyship to turn over to page 357, you'll see the officer's report. It's the assessment of the planning officer, having received the application for a certificate. And the first paragraph there at 357 is description of site and application. The application relates to houseboat 8, etc. And then four lines down, you'll see the permission is subject to condition 1, which states the houseboats hereby approved shall only be used as holiday accommodation and shall not be used as the sole or main residence of any person. The application is for a certificate of lawfulness for unrestricted residential use described as a sole residence on the basis that the condition has been breached continuously for more than 10 years. So I say that's unequivocal. The application was made on the basis of breach condition.
Have we got the application in the
We don't, I'm afraid, no. There is a difficulty with the planning documents in relation to this site, which are extensive. And this is the best I've got in terms of the documentation relating to the certificate that was granted. But there is no doubt in my submission, anyway, that the application, as it's said there by the officer, is for a certificate of lawfulness on the basis of breach of condition. So that's a section 1911C application, not a 1A. You see there the officer then sets out the planning history of the site, page 357, and the third entry is the relevant planning permission, 98 permission.
This was at the time when the period for enforcement was only 4 years, isn't it?
No, it's 10,
It's 10, is it?
it's 10 for use.
Oh, it's 4 for operational development.
Yeah, so it's
And
10
that's
for
now
use,
changed
10
to
for breach
10,
condition, 4 for operational development, and it's recently been changed in subject to transition arrangements. So it's 10 years for everything.
10 for everything now, yeah.
And then if I can ask you to turn over to page 359. The officer essentially is answering your question, ladyship.
Yeah,
Section 191 of the 19, the second paragraph down, sorry.
yes.
Under the summary of issues, the Section 191 of the 1990 Act provides a procedure whereby applications can be made for a certificate of lawfulness, existing use of development, where developments have been carried out or use carried out without necessary planning permission, or a planning condition has been breached but the time for enforcement has since expired. at the time period for force protection is 4 years for operation developments, 10 years for any other breach. If I actually turn to page 360.
Well, is it significant, sorry, just to go back to 359, the officer's report says the breach of planning control is not in this case an unauthorised residential use because the planning permission is for residential use, albeit one restricted by the conditions. So that's the way the officer seems to have analysed it.
It is, and with respect to the officer, I'm not sure it's quite right. Holiday use is a residential use. It's a caravan is statutorily defined as a structure which is adapted for human habitation. There's a whole range of types of human habitation, but one might colloquially think they're all residential purposes. But that residential purpose might be holiday use, or it might be a holiday use. So I suspect what the officer's saying there is that there is a plan. I mean, this clearly isn't a planning permission that provides for an unrestricted residential use. It's a residential use in the context of a holiday purpose only.
Right.
So I think it's inelegantly phrased there, but it's not the officer saying that there's an unrestricted planning permission for residential use.
It says you can live there, but there is a restriction on how long you can live there. You can only live there as a holiday home.
In terms of the condition, yeah. But one can't ignore the words in the description of development, and I will take your ladyship to the case law. They have a functional relevance when interpreting the permission. So I'm not sure the way the officers approached it, it's not incorrect, but it's slightly inelegant in terms of the holiday use is a residential use, but it's a particular type of residential use.
Take us to 360.
I think if I perhaps skip and go to 361 just to try and speed things up slightly. It's the final paragraph there at 361. So this is part of the officer's assessment, which he commences at 360. Then consideration of the specific case, the final paragraph. In order for a certificate to be granted in this case, the evidence has to show on the balance probability, condition 1, planning permission 1998, has been breached continuously for more than 10 years. So that's further evidence that this is something. Well, the application that was made, as specified in the report, is for a declaration that a condition has been breached.
It's for a declaration of lawful use.
Yes, it is, but there are 3 different types of establishing a lawful use: use of land or buildings, the building itself, or for breach of condition. What the application is, as expressed by the officer in multiple places through the report, this is what was in the officer's mind, is an application in respect of breach condition, which is on all fours with the reasons that are given for granting the certificate. And those reasons have to be provided, otherwise the certificate is defective. Therefore, they cannot be ignored. They form part of the certificate, which must be read as a whole. And then if your ladyship's turn over to page 362. You'll see the officer's conclusions midway down the page. Sets out at the beginning there the evidence for the condition having been breached continuously for 10 years or more prior to the date of the application. The officer's only considering whether the condition's been breached, because that's what he or she has been asked to do.
That's the justification for saying that it's now lawful use. This application wouldn't get off the ground if there hadn't been 10 years continuous occupation in breach of the condition.
The application, if it's made for the breach condition, has to demonstrate that the condition has been breached.
It would be exactly the same if they sent a letter in saying we're making an application for a change of use under section 1911A. The justification for that would be the same justification, wouldn't it?
It would.
Yes, exactly.
But that's not what was done, and that's not what was granted.
So if the application had been exactly the same application, and had been headed, this is an application under section 1911A, would the planning officer's assessment be any different?
No, probably not. But,
And he would still refer to the breach of conditions as the justification for the change of use?
well, not necessarily, no, Your Ladyship. He would refer to the evidence that's provided to show that the use has been continuing for 10 years.
Yes.
The knock-on effect of that is that the condition would have been breached.
Yes.
But that's not the application that was made. I understand the unattractiveness of this, but and I don't seek to try and get away from that. But the certificate says what the certificate says, and it's blowing a hole through the planning system. If one can go back and look at a certificate that's granted in one respect as providing for something that it doesn't provide for, because that then takes away the efficacy of lawful development certificates in the planning system. One will always have to go back and look at them and effectively reinterpret them or reassess them in the context of the application. That is precisely what the courts for many years said one cannot do. What is in the certificate is to be conclusively presumed as to be lawful. Now, there is an ambiguity, I say, in the certificate between...
The certificate says,
the
in
use.
terms, you can use this as a residential unit.
But the reason is...
That's what it provides for, doesn't it? Leave aside the reasons. The reason is what has led to the grant of the certificate, and it has to be put into the certificate. But the actual certification is you can use this as a residence. That's a granting of developmental planning control for use for lawful residence.
That's what the first schedule says.
Yes.
But one cannot look at the first schedule in isolation. That is what the
It
appellant
also
in
appears on the
Adams,
first page.
that's what the appellant in Adams tried to do. And Mrs. Justice Laing said that was wrong. One has to look at the certificate as a whole, as one looks at planning permission as a whole. So one cannot ignore the reasons because they are a statutory requirement. And if one was unsure about that, and I say there is an ambiguity there, so one looks at the officer's report, there is no ambiguity from the officer's report that considered this as a breach of condition application, not a change of use application. And if it's a breach condition application and grant, then it's not a standalone certificate. It has to be read with the 98 permission to give it some effect, because otherwise it doesn't have any effect. I accept that if it's a certificate granted under section 191, subsection 1, for a use as opposed to breach condition, then it is a standalone certificate, and that's in effect what the Upper Tribunal found. It said it can effectively dispense with the 98 permission because this certificate from 2014 commenced a new chapter in the planning history of the site, and it's that which is the governing consent, and it's that which on my the second limit of my argument to say is wrong when considering how one should approach the interpretation of certificates of planning documents. So that's the position with the statutory background and the facts. If I could turn then to the grounds of challenge, some of which have been foreshadowed and addressed, so I'll deal with them as best that I can. As I said at the outset, there are two limbs to the ground. Firstly, that we say that the 1998 permission does not provide for a caravan site of any type. And therefore, it's not a protected site. It can't be. It's not a caravan site. And that secondly, that the governing permission is the 98. Governing consent is the 98 permission, read together with the 2014 certificate, not the 2014 certificate alone. So it remains that only a holiday use is provided for by the description of development. Therefore, again, can't be a protected site in section 1, subsection 2A of the Caravan Sites Act 1968. So on that first limb, as we've already explored, it can only be a protected site if it has planning permission for a caravan site and one that is not described as being for a holiday use. Now, I don't think there's any dispute here. The 1998 permission it is clear whatever it provides for, in terms of whether it's a caravan, houseboats, or anything else, it is expressed to be for a holiday use. The 1998 permission can't provide for a protected site unless it provides for the stationing of caravans on land. And that is where the interpretive principles are engaged. Your Ladyships, I'm going to just take you to 4 authorities. If your Ladyships are familiar with them, I'm happy to be moved on in the interest of expediency. If I could ask you first of all, the overriding, the principal authority is that of Lambeth, London of Lambeth. It's at page 299 of the bundle, the authorities bundle. London of Lambeth Council and the Secretary of State for Housing, Communities and Local Government and others. Supreme Court. I'll ask you to turn to paragraph 15. Where Lord Calmworth sets out the principles of interpretation, which essentially follow on from the Trump International Golf Club case. It says paragraph 15, page 308 of the bundle. Can I ask you, Ladyships, is it distracting for me to read them out, the paragraphs, or is
Well, it depends on how much you want to read, but if there's any particular parts you want to emphasise,
yeah, okay.
then please do read them out.
Can I ask you to have regard to paragraphs 15 to 19,
Yes.
which is where the interpretive principles are summarised. The key issue, the key thrust, if you like, is at paragraph 19, where the court says, in summary, whatever the legal character of the document in question, the starting point, and usually the end point, is to find the natural and ordinary meaning of the words there used, viewed in their particular context, statutory or otherwise, and in the light of common sense. So that is the overriding approach to be taken to the interpretation of planning documents, whether they be permissions or planning permissions or lawful development certificates.
That's true. You don't construe them like statutes. You construe them, certainly planning decisions, you construe with a degree of liberality.
As common sense as a whole. And I accept that with certain caveats put in place as to when reference is made to the statutory or the particular context, statutory or otherwise, one must consider whether there are other constraints in play.
Yes.
But that's always the starting point, and may well in many cases be the end point. If I can ask you to turn to page 288. This is the case of Wall and others and Winchester City Council in the Court of Appeals, Lord Justice Sullivan, and in particular paragraphs 19 and 20, please. This was a case where it was argued that an inspector found that a planning permission for a travelling showperson site, by its very nature, because it involves residential caravans, also provided for planning permission or use of land for residential caravans. And what Lord Justice Sullivan found was that's not quite right, because you need to look at the words that are used in the description of development, because they have a functional significance, if you like. Paragraphs 19 and 20 there. Firstly, paragraph 19, and actually have reference to that, it's the approach taken. At paragraph 20, there's the limitation of the use to a site for travelling show people. That's what was in the description of development. It's just as much a functional limitation on the 2003 planning permission as were the limitations to agricultural cottage or site for caravans occupied by gypsies. So the thrust of this decision is that one can't ignore what is set out in the description of development, because that is that describes has a functional effect on what the permission provides for.
So you say by parity of reasoning, you can't read the grant of planning permission in this case also as a planning permission for the stationing of caravans.
I do so because it says houseboats, and houseboats are the houseboat may be a caravan.
Yeah.
But the Upper Tribunal found in this case that the houseboat in question in this case was not a caravan considered as a whole.
Yeah.
Because it failed the mobility test. And there's no dispute between the respective experts on that. There's no mechanism of lifting it out of the water without it collapsing. So it is important that the words houseboat are used in the descriptive development. They are, in the same way that travelling show people live in caravans, and the argument in this case
Yes,
was that
well,
travelling
that's
show
what my
people.
question was getting at.
Yeah. So this does go to the functional significance of the word houseboat in the descriptive development. And then just on a couple of other caravan specific cases, if I ask you to turn to page 356. This is Mrs. Justice Laing in the Planning Court, Hartford Caravan Park Limited, and the Secretary of State for Housing, Communities and Local Government.
So sorry, Mr. Rudd, I missed the page reference.
356, Your Ladyship. Particularly paragraphs 84 and 85. Where the court is applying the interpretive principles as set out in Winchester, specifically the functional significance of the words used in the description of development. And this is a case where there was a planning permission for one type of caravan use, and the applicant was seeking, and then appellant was seeking to argue that a different type of caravan use fell within. And as you see over the page at 378, sorry, 377. So the relevant words in the planning permission are the description of permission as the use of land for a holiday park. Just as the words highlighted by Justice Sullivan in Winchester at 20, which I take you to, are properly regarded as functional limitations on the relevant planning permissions in the Wilson, Williams and Stevens case, as well as the Winchester itself, the word holiday clearly qualifies the term caravan park. So it's emphasising the importance of looking at the words that are contained in the description development and the functional significance of those words. And the final case, which is along the same lines, you'll find at page 442.
But it might be important to look at 86 as well, where Mrs. Justice Laing said that the site fell within the broad statutory definition of a caravan site, on which caravans as defined in the 1960 Act was situated, but the planning permission was not granted for a caravan site. Yeah.
Because this was a case where the appellant was arguing that regardless of the fact that the planning permission was use of land for a holiday caravan park, the appellant was arguing that you can't have a restriction in the description of development. It has to be by way of a condition. Therefore, the word holiday could be disregarded.
Yeah.
So you have a use of land as a caravan park. And Mrs. Justice Laing is saying that's quite right in the sense that the permission did grant planning permission for in a wider context for the use of the land as a caravan site, but one cannot ignore the wording in the description of development, which included the word holiday. And the word holiday had a functional significance in defining what the permission provided for. Didn't provide for a caravan park per se, it provided for a holiday caravan park.
Yep.
And then finally, page 442, St Anne's Court, Dorset Limited, and the Secretary of State for Housing, Communities and Local Government. And it's James Strong, QC, sitting as Deputy Judge of the High Court. And it's again the court applying the interpretive principles again in the context of a caravan site. seeking to go from one type of activity to another. Paragraph 55 onwards, at page 473. And this was a planning permission, right? This was a case that related to a planning permission that had been granted for touring caravans. And the argument was that the word touring could be disregarded because it was a limitation which shouldn't be in the description development. Therefore, it's a planning permission for caravans. It just so happens to be the same planning agent as it was in the Norfolk Park Homes case, applying the same arguments. You can disregard the word touring. So you've got a planning permission for caravan sites, so any kind of caravan can be put on the land. And what the judge is saying at 55 there, he considers, having gone through the principles set out in the approach considered by Lord Justice Sullivan in the Wall and Winchester case, then finds that paragraph 56, in my judgment, the limitation of the use to the site for touring caravans is just as much of a functional limitation on the 1980 Planning Commission as were the limitations to agricultural cottage. So taking the same approach as Lord Justice Sullivan. The words are important. It might be that the site does provide for a caravan site, but it's a particular type of caravan site. I say in this case, what the planning permission provides for are houseboats. It doesn't provide for anything else. They are houseboats as considered by the council as granted, not caravans. As we'll come to shortly, the Upper Tribunal found that the houseboat wasn't a caravan and couldn't be. They're the authorities at this point I place reliance upon in terms of the interpretive approach to be taken. So in summary, from those authorities, I said the words in the descriptive development have a functional importance, a functional significance, and that is what provides for the permission. And one has to apply common sense in the interpretation of that description development in this case, in the context of the natural and ordinary meaning of the words used. So when planning permission was granted for houseboats, is it a natural common sense conclusion to reach that the planning permission provided for a caravan site? And in my submission, it's not. I mean, that's a gigantic leap. If I can then just refer to the Upper Tribunal and the way that they approached, in practical terms, of what was before. And it's in the first bundle, materials bundle. And I want to go to paragraph 27 first, which is on page 89. This is important because I say the planning permission has been granted for a houseboat. That's what it says, that's what it provides for. And the Upper Tribunal say, the question in this case, and not as the First Tier Tribunal put it, whether Ms Jaffe's property is a statutory caravan, the property taken as a whole is a houseboat, comprising a caravan and a float. Taken as a whole, her property is not a caravan because it fails the mobility test. As the appellant says, it cannot be towed because the caravan has wheels, but the float does not. And it was agreed between the parties, expert witnesses, before the First Tier Tribunal, that it cannot safely be moved as a whole. Learned friend does not seek to argue that houseboats as a whole is a statutory caravan. So that's, if you like, the starting point in practical terms. We have a planning permission for houseboats, and we have an undisputed finding that the houseboat is not a caravan. And if it's not a caravan, it can't, then the permission can't provide for caravan site. If we ask, then if we turn to, so we look at paragraph 32, and just 3 lines from the bottom of that paragraph. Tribunal find that Ms Jaffe has no permission to put the caravan alone on the water whereupon it would sink, nor does she have permission to place it on dry land. She does not have to show that she has permissions to do either of those things. The point being that the permission, as I keep saying, is for the whole. There's no planning permission to put the Willoughby caravan, which forms a part of the houseboat. The planning permission relates to the houseboat, and that's the functional significance of the words in the permission. And then finally, if I ask you to turn to page 92. That's paragraph 47. It's 4 lines down. It's line, the sentence starting, in granting permission for houseboats, the local planning authority gave permission for both of the 2 components of those houseboats to be on the land, albeit only when put together in the form of a houseboat. And that is my point. The permission relates only to houseboats, provides only for houseboats. And the houseboat, the tribunal has found, is not a caravan. I say that just applying common sense, looking at the natural and ordinary meaning of the words, and then considering the findings of the Upper Tribunal. The word houseboat, the phrase houseboat, which is a use of land, provides for a functional limitation on the permission. Take your ladyships to Winchester, St Anne's and Norfolk. And the permitted use that is granted is for the stationing of the houseboat on land, not a caravan on land. It's the houseboat. I accept, it's not in dispute, that placing a structure on water is the equivalent of placing it on land for the purpose of town and country planning. But what is placed on the land is the whole structure, not just the houseboat. Not just the caravan, sorry. And the planning commissioners that the Upper Tribunal have found, and I accept and endorse that finding. You can't treat the parts separately. So how then will the Upper Tribunal resolve this dichotomy they got themselves into? What they do, wrongly I say, is seek to separate the caravan and the float. Having found that the planning permission is for both, and you can't place one or the other separately, they equate the float to the concrete base that a caravan would be placed on, normal caravan placed on in normal circumstances. And they say that the base becomes part of the land. I don't dispute that in terms of the concrete base. It's a structure, it's a building, if you like, that's created, becomes part of the land, and a caravan is placed on that base. Now, I say that approach is flawed because, firstly, the planning permission, as I demonstrated to your ladyships, development under section 55 of the Act comprises essentially 2 different types of development. One is operational development, one is a change of use. What has been granted planning permission here is a change of use. A concrete base would be operational development because it's a structure. It's not a use of land, it's a building operation. I don't think that will be disputed by my learning
Why
friends.
is a pontoon not a structure?
The pontoon is a structure in the same way a caravan is, but it's not a building operation. It's part of the houseboat.
Sorry, you mean the float?
The float, yes, I said.
Yeah.
So in normal terms, if one was receiving planning permission for a conventional caravan site that included the provision of concrete bases and roads and fire hydrants, etc., toilet block, it would be a hybrid permission that provided for a material change of use of land for the stationing of caravans, which is a use of land. Stationing a caravan, placing a caravan on land is a use of land. So the material change of use for the stationary caravans and associated operational development, which would be the concrete bases and the other building operations, the digging of holes, filling of concrete, etc. Filling with concrete, that's a building operation. This is the planning permission that's been granted. They're two separate acts of development. One is a use, change of use, and one is a building operation. The planning permission that's granted in this case does not provide for that. It provides for a single act of development, which is a change of use for the houseboats as a single indivisible unit, as accepted by the tribunal. It might help if we have just a quick look at section 336 of the Town and Country Planning Act, which deals with definitions. You find that page 84 of the materials bundle, authorities bundle. It's page 33. It's paragraph 33, section 336 of the Town and Country Plan 1990s. The interpretation section, at page 84. Just towards the bottom of the page there, you'll see the definition of land. Including a building. A building is something that's created, is a building operation. You can't create a building by way of a use of land. It's a separate operation. So if the concrete base is to become part of the land, then it has to be a building, which is operational development, not a use of land. And the planning permission is granted only for a use of land for the stationing of houseboats, which, as I said, the tribunal finds are not caravans when considered together. So I say it's an entirely artificial approach to then, having made that finding that what the planning permission was granted for as a whole, you can in some way subdivide to equate it to similar circumstances to the stationing of a caravan as a use, and a base which becomes part of the land because it's a building. The float, in this case, is not becoming part of the land. It never does. The float is inherent and integral to the houseboat. It is essential because the houseboat can't exist without the float.
I'm just wondering if I goes back to the certificate of lawful use at page 354 of the this is second supplement or second bundle. I see your submission. You've got to read it as a whole. So the use which is described is Schedule 1, certificate of lawful use as existing for occupation as sole residence. But it's important to read that in the context, perhaps, of what land is specified in the second schedule. And the land that's specified in the second schedule is houseboat 8, Westbourne 2.
Yeah. Because there isn't planning permission for anything else.
Yeah, so that's your point, really, isn't it?
Well, the planning permission only relates to houseboats. So whatever the 1998 planning permission relates to, I do say you can't treat the. I accept it's unattractive because the wrong application perhaps was made in terms of the 2014 certificate. But you can't separate the 2014 certificate from the 1998 permission because it's the 1998 permission that provided in the first place for what was going on. And what was going on, because it was retrospective, were houseboats floating on the marina that were placed on land. The float doesn't become part of the land. The float is part of the houseboat and remains part of the houseboat. The difference with caravans and concrete slabs is the concrete slab never becomes part of the caravan. The concrete slab becomes part of the land. The caravan has to remain a statutory caravan in that it has to remain movable. It has to pass the mobility test.
Yeah, no, and the point, well, perhaps one of the points is that the certificate of lawful use relates to the land that's specified in the second schedule, and that's not the caravan, it's the houseboat.
It's a houseboat because the thread through the thread through the whole purpose of the marina the grant of the planning permissions, the use of the marina is houseboats. Nobody for 1 second considered until the application was made that these houseboats on the river were caravans. They've always been treated as a houseboat, as described in this particular case in the permission. And the certificate continues that consistency throughout. So I do say that the Upper Tribunal were flawed, having found that the houseboat as a whole can't be a caravan, and I don't get any disputes over that. In then trying to arrive at a conclusion where the caravan on the houseboat is placed on the land takes an entirely contrived and artificial approach to extracting the float from the houseboat, and saying that becomes part of the land. It cannot become part of the land. There's no planning permission for operational development. It sits on the land and must remain as part of the houseboat. It can't be separated. There is no equivalence between the float and the concrete base, if one was dealing with a caravan on land. And the planning permission only provides for a change of use, no operational development in the context of the houseboat. And I say, respectfully, that is determinative. And then, if I can ask you to turn to page 93 of the Upper Tribunal decision. Paragraph 48. There's no inconsistency here with the decision in Winchester City Council. It's important to note that the Court of Appeal did not decide, as Mr. Wood suggests, that the planning permission did not provide for use as a caravan site. What the Court of Appeal decided was the planning permission did not provide for the stationing of caravans by anyone other than travelling show people. And importantly, the 1998 permission, and that's what we're looking at the moment, is interpretation of that permission, is a planning permission for a caravan site. It is not a permission for the stationing of caravans other than in the form of houseboats. The planning permission, if the Upper Tribunal is saying it's planning permission for the stationing of houseboats and not for the stationing of caravans other than in the form of a houseboat, and has previously found that a houseboat is not a caravan because it fails the mobility test, then there cannot be a planning permission for a caravan site.
It's quite hard to understand those two sentences.
Yes, it's just wholly inconsistent with the previous finding that the houseboat isn't a caravan. And if the houseboat isn't a caravan, the permission can't provide for a caravan site. It is, in my submission, taking that paragraphs 27, 32 and 47, which I've already taken your ladyship's to, wholly inconsistent approach. And the reason for that is because the tribunals tried to wrongly, I say, separate out the float and the caravan, having found that the houseboat as a whole, for which planning permission was granted, is not a caravan, and therefore the planning permission can't provide for a caravan site. So they have to go down another road, which is this flawed approach of trying to separate out what the planning permission provides for. And that you're going back to the starting point. This is not a common sense approach. This is not the natural and ordinary meaning of the words contained in that permission. It is in fact a contrived approach that offends common sense, in my submission. The hoops that have to be jumped through to get to this position, and I think respectfully say the Upper Tribunal got themselves into a bit of a twist over how they approach this, and it's very difficult to reconcile those paragraphs. And the reason it's difficult to reconcile those paragraphs is because this planning permission, granted in 1998, is a planning permission for a planning permission for sui generis use, and use only, a use for houseboats. The caravan use is a different sui generis use, and that is not provided for by the 1998 permission. And if the 1998 permission does not provide for caravans, regardless of whether it refers to holiday or not, it cannot provide for a protected site. and there cannot be an agreement under the Mobile Homes Act, because the Mobile Homes Act 1983 only relates to sites that have planning permission as a caravan site. Unless I can assist your ladyships any further on that first limb, I will be briefer on the second limb. We've actually covered some of the ground anyway. So your ladyships, you know my position on the certificate. I say it's a certificate granted subject to pursuant to 1911C as a breach of condition. I should have said, if I succeed on the first limb, you don't need to consider the second limb. If it's not planning permission for a caravan site, it doesn't matter what the certificate does. If I don't succeed on the first limb, then one needs to consider what is provided for by the certificate. And if I ask your leaderships to look at paragraph 50 of the Upper Tribunal decision at page 93. So in the Upper Tribunal, the judge breaks down the second question of protected site into two questions. I've just dealt with the first question, which is the interpretation of the permission. The second question, as you see there, just above paragraph 49, is did the planning permission in relation to Ms. Jaffe's pitch fall within section 1 and 2, A or B of the 1968 Act? So my second limb relates to this the second question, if you like, of the Upper Tribunal. Paragraph 50. The judge says, obviously, if Miss Jaffe relied only upon the 1998 permission, she would fail. That permission is clearly expressed to be granted for a holiday use only, both by virtue of the description of what is permitted, which incorporates a functional limitation, and by virtue of the first condition, paragraph 10 above. So there's an oddity there, because the functional limitation
There's a recognition of the
the
functional limitation.
in the sense of holiday, but not in the sense of houseboat. And I say operates, the functional limitation relates to both. It's in the same way that in the Wall of Winchester case, travelling show person was a functional limitation, houseboat is a functional limitation, a touring caravan is a functional limitation. So there are two functional limitations in the description development. One is houseboat and one is holiday, and they are what define what the permission provides for. So given the Upper Tribunal's finding there that 1998 permission can't be relied upon, there must be another governing consent. Some other consent that provides the use of the land that would allow that use to fall under the Mobile Homes Act. And the only available consent is the 2014 certificate, which I say in those circumstances has to be a standalone certificate, because the provisions of the 98 permission can no longer continue to have effect because they constrain the use to one that falls outside of the Act. Now, what the Upper Tribunal find, paragraph 64, what they conclude, the judge concludes. Paragraph 64, page 97. The certificate is therefore a certificate under section 191 in respect of the use of the land, as section 1917 says, and therefore is effective to grant a planning permission. And that's the crux. What is the effect of the if the 1998 permission provides for a caravan site, then it's limited to holiday use. And I because of that limitation, I succeed at that stage. But if then the certificate takes away that limitation because it's for a use rather than a breach condition, I'm in difficulty, and that's what the Upper Tribunal found. And I say that the certificate doesn't do that, even if we get to that point in the argument. It's not. The use was not what was sought. The use was not what was assessed by the officer, and in my submission, it's not what was granted. Now, we've already been through the difference between section 191A and C. I'm not going to go back over that again.
Well, your main difficulty with all of this is that the certificate actually says in terms that that the use of it for residential purposes is lawful.
Under the first schedule, yes. I accept that. And
that must be the governing, that is what the grant is given by It's not saying you can't enforce for lack of for breach of conditions. It's saying you can use it for residential purposes.
But is it significant that that you can use for residential purposes is the houseboat rather than
Yeah.
the caravan?
Well, that relates back to the first point, of course. Yeah.
Well, it might be if I'm wrong about the certificate and how one should interpret the certificate, it still only provides for use of the houseboat.
Yeah, that's my point.
Yeah.
Doesn't
So,
provide,
so
doesn't,
this is a point that relates both to the first argument and potentially to the second argument.
and in terms of the end,
Yes.
where everybody goes next in terms of the use of the land.
Well, I'm just asking because it seems to me, just looking at the terms of the certificate, which we did a minute ago, that the certificate doesn't say you can use a caravan for residential purposes. It's talking about a houseboat. It's talking about
The caravan is an integral part of the houseboat, and there's nowhere else you can live.
yes, but it's the
Um,
whole thing.
You've got to apply a degree of common sense to this.
But you have to interpret the planning permission in the context of what it provides for and what the Upper Tribunal found it provided for. It's if I, as an anecdotal example, if I build a house but incorporate a caravan into my garage and live in the caravan, I'm not living in a caravan, I'm living in a house. No one's going to suggest it's a caravan site. What's been granted planning permission is the houseboat. What the certificate relates to is the use of that houseboat. Now, that's one limb. I would say it relates to the use of the houseboat and nothing more. And that houseboat is not a caravan, nor can it be. The caravan is a caravan, but the houseboat is not, and there is no permission for a houseboat, for a caravan. The point of these certificates is they have to be. But your ladyship, so I'm going to move on to some of the authorities, and it would be a good time to break.
Yes, I would have thought so. How much longer do you think you're going to be? There's no pressure, I think.
I would hope to be no more than 30 minutes.
All right, well, that's fine. Well, shall we say 2:05?
Thank you, Alicia.